Thank you for joining us at Capstone Coffee Conversation. My name is Russ. My name is Ryan Skokstad, and I'm sitting next to Russ Getchell. I'll let him introduce himself in just a second, as long as I can remember who I am. Today we're going to talk about estate planning, and we'll get into some kind of some do's and don'ts and some things to focus on. One thing I'd like to say before we start, if you have questions that you would like to address to Russ, please chat those to the host on your Zoom. You can just hit the little chat button, type a question in to the host, and at the end of the discussion, then we'll field those questions and have Kennedy send those to us, and we'll try to hit on all those questions when we're all done. So as we go, feel free at any time, please chat those questions in to the host. Again, thanks for joining us. I'm going to have Russ introduce himself, and then we'll go through a few pieces on kind of the tenets of estate planning.
Hi, I'm Russ Getchell. Thank you for that introduction, Ryan. I'm an estate planning attorney here in Salem, Oregon. I graduated from Willamette University College of Law in 2010. I did general civil litigation for the first 2 years, doing foreclosures, divorces, custody battles, and evictions. And after that, I transitioned into estate planning. I've been doing that since the very beginning of 2013. Live here in Salem with my wife and my 3 kids, and I really love it here. One thing I am obligated to say before we get started is that the information in this presentation is general in nature and should not be relied on as legal advice. If you have specific questions about estate planning or tax planning, you should consult with an attorney or CPA licensed to practice in your state. So.
Awesome, thank you. And our office has worked closely, and I personally have worked closely with Russ in their office for many years now. And so we wanted to invite them on here and have them share some insights with you all. You know, we've been trying to invite people from other genres from just the investment markets to join. I think that is helpful because obviously our office is dealing with allocation and investments and economy and what have you, but there's a lot that goes into financial planning. And so having Russ join us today, thanks for being here. So let's just start at the 30,000 foot view. Give us, if you would, the basic elements of an estate plan.
Sure, a comprehensive estate plan should address 3 different areas. The first is incapacity planning, making sure the documents are in place so that someone can make decisions for you if you're unable to make them for yourself. The second is tax planning, looking at the estate tax laws that are applicable to you and based on the assets that you own, and also the role that income tax and capital gains tax will play in the estate planning process. And the third is what people usually jump to first, which is what happens to my stuff if I die, and making sure that there are the documents in place to direct where your assets pass at your death, who you want to get them, and how you want them to get them as well. So.
Okay, so let's just hit on a few of those. I heard you say a few different things there. And we'll just go kind of in order as you laid them out. Planning for incapacity, what does that entail? What should people be aware of? How do you focus on that?
Sure. In any estate plan that we do, whether it's a will-based plan or a trust-based plan, regardless of the size of the estate, there are a couple of documents that we draft for folks. And the first is a document called an advance directive. Depending on the state that you're in, it might have a different name there. But an advance directive in Oregon allows you to appoint a healthcare representative to make healthcare decisions for you if you are unable to communicate with the doctors and nurses about what your wishes are. And authorizing anything from a course of antibiotics to surgery. It also allows you to express your wishes when it comes to end-of-life care, the withdrawal of tube feeding, life support, and breathing machines and dialysis machines, and express your wishes about those very difficult topics. The second document we do for folks is a durable power of attorney, which allows someone to make healthcare decisions for you, or financial decisions for you if you're unable to manage your financial affairs. Everything from opening bank accounts, paying bills, selling property, canceling gym memberships, taking care of pets, and filing tax returns. And we also do a HIPAA authorization allowing the people named in those documents to have access to your healthcare information. So either for paying medical bills or also for making healthcare decisions.
Okay. One thing I notice being in our office, a lot of times people will say, I already have a power of attorney, so that's all taken care of. But a lot of times your financial institution, like ourselves, will also need a form signed as well on our paperwork. So sometimes having that first draft done, the durable power of attorney, but then also translating that into your financial institution's power of attorney, because they might have to have one also on file. So just something to be aware of, because a lot of times people say, I already have that, I don't need that. that's true, but we also need it as well. Okay, the second thing that you mentioned, kind of in the basic elements, tax planning. So give us a little bit, update me on what are the federal exemptions today for tax planning with the states, and then maybe even some of the state exemptions that you deal with.
Sure. So the first one we talk about is the federal estate tax. We start by creating inventory of a client's assets, determine what estate taxes are going to apply to them, whether or not the federal or the Oregon estate tax systems will apply to them. In 2023, the federal estate tax exemption is a very healthy $12.92 million, and that is indexed for inflation. So next year it's going to go up a bit. I should add that is scheduled to have after the year 2025. So if it's $14 million in 2025, it's going to be $7 million in 2026.
And can I stop you just there for a second? So in other words, today it's about 13 million federally. You pass away with 13 million or less federally, then your estate doesn't have to pay a federal tax.
That's correct.
And then, but then in 2026, it might go down to about 7.
Yes.
Okay, that's a big change, big difference.
And the federal estate tax, if your estate exceeds the amount, those amounts is 40%. So it's a very steep tax.
Okay.
So big exemption, pretty large tax. So now it was not always this very healthy, almost $13 million exemption. I believe in 1997 it was only $600,000 with the excess paying taxes at 55%. So, but right now we have a slightly lower tax rate and a much larger exemption. But it is one to keep an eye on because it does move around.
Yeah.
Here in Oregon, like some states, we have a state-specific estate tax as well, which applies to Oregon residents and also non-residents who own property in Oregon. The exemption is much lower. It's $1 million exemption, and the tax rate is lower as well. It's a graduated tax, which starts out at 10% and tops out at 16% when you hit 9.5 million. So, and with proper planning, a married couple in Oregon can shelter up to $2 million from the Oregon estate tax. And for the federal estate tax, again, proper planning or a concept called portability, which you should speak with your CPA about, will also allow a married couple to make use of both of their federal exemptions to pass those assets free of federal estate tax at the death.
Off the cuff, do you know, does Washington follow the federal limit, or do you know Washington's?
No, Washington, I'm not as familiar with Washington law because I practice in Oregon, but I believe the Washington exemption is just over $2 million, and so a bit larger than Oregon, and but it's not a round 2 million. I believe it was indexed for inflation until it was capped at a certain point. I am not familiar with the Washington state tax rates.
Yeah,
I want to say 13%, but I'm not solid on that.
But it's not the 13 million that's a Fed.
It is not.
Yeah.
No.
And that's grown a lot then. So 600,000 in the late 90s, you said that might have been hitting quite a few people, where today 13 million, and that's a big difference.
Most people will not have to worry about, or under the current exemption, do not have to worry about the federal estate tax.
Okay. What about people that have, we have a lot of clients or people that, maybe live in Washington or Oregon, but then also have property in like Arizona or Texas or Idaho. How does that work for people that have, kind of dual state or properties in multiple states?
That's a great question. And it's somewhat of a complicated answer. The first thing you need to find out is where you are actually treated as being a resident of, because that really determines how your property will be taxed at death. And some states have statutes that say, define how residency is determined. So that's something you want to talk with a CPA or a lawyer about. But here in Oregon imposes a tax, like I just said, on people who are residents and die in Oregon based on the percentage of their estate that is located in Oregon. So if you have a person who is an Oregon resident and they die in Oregon, let's say they have an estate of $1.5 million, but half of that estate is a house in California, so worth $750,000. You would start by calculating the amount of tax we do if everything were located in Oregon, which on a estate of $1.5 million would be $50,000. And then you prorate it based on the amount of property that's actually Oregon is able to tax, which is for an Oregon resident decedent, it's their real property, tangible property, and intangible property located in Oregon. So if only half of it's located in Oregon, then the tax of $50,000 be prorated down to $25,000.
Okay.
Now it's a different result if it's a non-resident decedent, because under those circumstances, they can only tax the tangible personal property and real property that's located in Oregon. So it wouldn't they wouldn't be able to tax a California resident's IRAs, just the actual physical things you can touch that are located here in Oregon. So if you had a California resident who had a $500,000 California home and a $500,000 IRA, and then a $500,000 Oregon home, then because now only a third of the estate is located in Oregon, that $50,000 tax should be prorated down to 1/3 of that, so about $16,000 or $666.
So just because you're a resident of one state, maybe with a property in a different state, you could have estate taxes in that second state, even if you're not considered a quote unquote resident there.
Yes, even if you or a California resident, you only have a small amount of property here in Oregon. If your estate exceeds, your gross estate, wherever located, exceeds $1 million, then you could have to pay Oregon state tax.
Yeah. Okay. Good. Let's move on to when I pass away. I hear the kind of dirty word of probate. What is probate, and how can one avoid probate?
Probate is the court supervised process where a person's assets that they own in their own name without a beneficiary designation are passed according to their will if they have one, or if they don't have a will, then according to the state law of intestate succession. It's during this process where you collect the assets, you pay their bills, you file the final tax returns and paying tax. And then at the end of the process, then those assets are distributed out according to the will if they have one, or if the law if they don't. Probate in Oregon usually takes between 9 months and a year to get everything completed. And it's a rather slow and sometimes expensive process that can frustrate people. But there are ways to avoid it. Again, it's only necessary for assets that a deceased person owns in their name without beneficiary designations. So the first way to avoid it is if you have an asset that you own jointly, would write a survivorship with somebody. For example, married couples typically own their houses as tenants by the entire year in Oregon, and ownership will just pass to the survivor when the first spouse dies without the need for probate or any other kind of estate planning for that matter. The same is generally true for bank accounts and cars for married couples. Another option is assets with beneficiary designations, for example, IRAs, 401ks, bank accounts, life insurance policies, and securities. All have the opportunity to name who gets that when you die. And that passes as a function of contract you have with that custodian, and it doesn't have to pass through probate as long as it's filled out. Another way to avoid probate is to move your assets, other than retirement accounts, into a revocable living trust. And then those assets will pass under the terms of the trust, and it's not necessary to probate those assets as well. There's also for real property here in Oregon, we have what's called Oregon's transfer on death deed, which allows you to essentially name a beneficiary for your real property, and it'll pass to them, to that beneficiary of death. There are some drawbacks to going that route as opposed to a revocable living trust, namely here in Oregon, because it creates an 18-month period for creditors to satisfy any claims they have against the deceased person out of that property, and so it'll cloud title for 18 months. And so it'll make that property difficult to sell. So, a lot of states have transfer on death deeds, but the laws for each are different. So, and sound like a broken record, consult with an attorney licensed to practice law and state living.
I sometimes I've run into clients that they say, I'll see that they have a joint account, and they say, yeah, but we've done a trust, but they haven't put those assets, that joint account, in the trust. That joint account would still then go through probate, even if they've done the work and done a revocable living trust. If your assets are not held correctly, they could still go through probate. Is that correct?
Yeah, for bank accounts, a lot of times what married couples will do, yes, that's correct. But just because it's in a couple has a trust and the account is in their name doesn't necessarily mean it will pass through probate. A married couple can name their trust as the death beneficiary of that account. So it'll remain in their names while they're alive, but at death it'll pass to the trust. Some people find that preferable to hold their bank accounts in their joint names during their life, but payable on debt to their trust at death, because that way they don't have to go through the hassle of opening new accounts, getting new checks, redoing their automatic bill pay. So you just got to make sure the bank accounts are in the trust or payable on death to the trust.
Okay.
That option is fine. Just make sure you do one of them.
And you may have hit on this already, but how about the will versus a trust and probate, how they differ?
Yeah, so both wills and trusts do the exact same thing in that they allow you to direct where your assets will pass at your death and who will receive them and how they will receive them. The benefit to a trust is because you transfer your assets to a trustee, And then if you are unable to manage your act of the trustee, then a successor trustee steps in. It's not necessary to probate those assets because technically legal title is vested in the trustee and not your individual name. And so that's how it avoids probate.
Okay. For folks that maybe have, heirs or they want to do some gifting, maybe their estate's growing larger and they're kind of thinking of ways that they can benefit others, maybe family or outside family. Give us some pros and some cons of gifting while I'm alive still, rather than just having beneficiaries after I pass.
Yeah, so the big benefit to gifting is that it allows you to remove an asset from your taxable estate when you die. So for example, let's say you have $1.5 million as an Oregon resident, and you want to make large gifts to reduce your exposure to Oregon state tax to under $1 million. And you can make gifts while you were alive to your loved ones or any other beneficiaries to reduce the amount of tax that would be amount of assets that are subject to tax at death. We have a lot of clients who are hovering right around that $1 million mark, and so each year they're making enough gifts just to keep them right under it. Also making sure that they have enough left to take care of their own needs. Another benefit other than estate tax savings is you get to see your loved ones enjoy their inheritance while you're alive as opposed to after you're gone. The drawbacks to these, one is obviously you lose the value of that asset. Once you gift it to someone, it's no longer yours. And if you need it later, well, that's a conversation you have to have with whoever received it. Second drawback is if you gift appreciated assets. So if I gift a share of stock that I paid $10 for to someone, now it's worth $50, I can gift that to them. But if they sell it, they're going to have to pay capital gains tax based on my $10 basis and the $50 value of it. Compare that to what happens if somebody inherits an asset from you where they take a new basis based on whatever it was worth on the date that I died. And so you need to be mindful of what you are gifting and whether it's ever going to be sold. Now, obviously, cash is if you have cash, is a great thing to gift because that's just the basis is whatever it is.
Mm-hmm. So gifting non-appreciated securities, if possible, and passing away with appreciated securities is the best taxation strategy if people have that option.
Yes.
Yeah.
And that's a good conversation to have with your financial advisor to identify which securities you want to gift. And another thing to be mindful of is if you, Oregon does not have a gift tax, but the federal government does. And so if you gift above the annual exclusion, which this year in 2023 is $17,000, you need to file, talk to your CPA to file a federal gift tax return. And what that does is, let's say I give a gift of $117,000. The first 17 qualifies for the exemption, but the additional $100,000 will be deducted from my estate tax or federal estate tax exemption. So if I get to $100,000 in excess of the annual exclusion, instead of having $12.92 million to leave at my death, I'll only have $12.82 million left.
No problem. Yes. Yeah. Okay.
So most people can gift without suffering any consequences.
Awesome. At least on the federal side.
Yeah.
Well, thank you, Russ. I want to turn it over to you guys now. And Kennedy, is there any questions?
One question came in, and I don't know if we covered it already, but under what typical conditions does a couple establish a revocable trust?
Under what conditions?
Under what typical conditions does a couple establish a revocable trust?
So this would be, that would be, you have to look at the trusts are more expensive than wills, so it have to be that to need the assets to justify that. They would generally do it if they wanted to make things easier for their children at death, because trusts are typically generally easier to administer than wills because you don't have to go through the court process. It's also a more efficient means for estate tax planning. I talked earlier about how with proper planning, a married couple can use both of their applicable exemptions, and trust is a more efficient way to do that. Trusts are also a good incapacity vehicle. The assets that are owned by a trust can be managed by the trustee in the event the trust makers, whoever establishes the trust, become incapacitated. So, and then work in conjunction with the power of attorney, which would be used to manage non-trust assets like IRAs.
Good question. Okay. Well, Russ, I appreciate your time. Thank you for being here. And again, as always, as Russ kind of mentioned at the beginning, a lot of this is just to kind of introduce people to the topic. But as you have more questions, feel free to reach out to your advisor, reach out to your local estate planning attorney, and we're happy to refer people to somebody if they need help in finding somebody. Thanks for joining us at Capstone Coffee Conversation. We look forward to seeing you next month.